imagine this for a second. You're a child, and your parents are in the middle of a really, really bitter divorce.
Awful.
Right. And then one of them demands a DNA test on you. Not to disown you, but just as a weapon. To prove that the other parent had an affair.
Using the child's identity as leverage in a fight between adults.
Exactly. That devastating scenario is right at the heart of a landmark 2023 Supreme Court case, Aparna Ajinkya Firodia versus Ajinkya Arun Firodia.
It forces a really tough question.
It does. It asks, and this is something for you to really think about, does a parent's right to get evidence for their trial, does that override a child's fundamental right to privacy, to dignity? Okay, let's unpack this.
So the background facts are pretty straightforward on the surface.
Yeah, they married in 2005. Their second son, who the case calls Master X, was born in 2013.
And this is the critical part. The husband himself admitted they were living together when the child was conceived. The law calls that access.
Right, access. But then, by 2017, he files for divorce. He claims he found evidence of adultery, some WhatsApp messages, a diary, that sort of thing.
Exactly. And he wanted that DNA test to be the final nail in the coffin, to make his circumstantial case, absolutely conclusive.
But the courts were split on this.
They were. The family court and the Bombay High Court actually sided with the husband. They felt it was necessary to find out the biological truth for the sake of, quote, justice.
But the mother appealed. She argued this wasn't about justice. This was about causing irreparable harm to her child.
And that's the core conflict the Supreme Court had to resolve. How do you protect a child when the search for truth could destroy their world?
So what legal principle did the court fall back on? How did they shield this child?
What's fascinating here is this incredibly powerful piece of law, Section 112 of the Indian Evidence Act.
Okay, Section 112.
It's basically a legal shield. In plain English, it says that if a child is born during a valid marriage, the law considers that conclusive proof that the husband is the father. End of story.
Conclusive proof. Not just strong evidence, but conclusive.
Precisely. It's designed to protect a child's legitimacy and social standing above all else. And there is only one way, one single way to get around it.
Which is?
The husband has to prove non-access. He must show that he had absolutely zero physical opportunity to be with his wife when the child could have been conceived.
So he would have to prove it was physically impossible for him to be the father.
Yes. And here's where it gets really interesting.
He couldn't do that.
He couldn't. He admitted they lived together. So his own testimony made it impossible for him to meet the only legal exception. He was asking science to do what the facts wouldn't let him do.
And the Supreme Court saw right through that.
They did. They delivered this powerful ruling basically saying a child is not a material object.
Yeah.
You cannot use a human being as a forensic tool, as a pawn in a marital dispute. It violates their dignity under Article 21.
So they created a new standard.
Yes, the eminent need test. The court said a DNA test is such a deep invasion of privacy that it can only be ordered if there is an imminent need.
Meaning the case absolutely cannot be decided without it.
Exactly. And since the husband already had his diary and messages, he had a path to try and prove his case. He couldn't just take a shortcut by violating his child's rights.
I love that distinction. And there was that great analogy, the outer fence.
Oh, the outer fence, yes.
Yeah.
Justice Ramasubramanian's concurring opinion, the brilliant way to picture it. He said Section 112 is like an outer fence around a property.
Okay.
The husband has to first prove non-access. He has to get over that outer fence. If he can't even do that, the door to the house, which is the DNA test, remains completely shut.
So it distinguishes between biological fact and legal status.
Perfectly. It separates genetic paternity from legal paternity. The law's job isn't always to find the biological truth, but to uphold the legal and social status that protects the child.
And so the Supreme Court set aside the lower court orders and denied the DNA test. So what does this all mean? What's the big takeaway for you listening to this?
I mean, the takeaway is huge. This precedent firmly establishes that a child's mental health, their dignity, their very identity, all of that is prioritized over a parent's legal strategy in a divorce.
The child's well-being comes first, period.
Absolutely. The decision sends a clear message. While science can give us biological facts, the fundamental duty of the law is to protect the most vulnerable.
It's a powerful reminder of that balance, isn't it? The cold, hard certainty of science on one side and the profound, human-centered protection of the law on the other. Something to really think about.